Welcome to the Celebrity Estates Wills of the Rich and Famous podcast. In this podcast, we break down high-profile celebrity estate planning cases for advisors and their clients. Most celebrity estate catastrophes are based on the same issues that everyday people face, just with the volume turned up. Our goal is to identify and extract the individual estate planning issues that lie at the heart of each story. We then discuss what advisors should expect and how to avoid common pitfalls. Hosted by wealthmanagement.com senior editor David Lenok.
Every estate tells a story. Some define a legacy, while others highlight lessons learned the hard way. To avoid costly planning pitfalls, trust companies, banks, and wealth management firms rely on the full suite of modern solutions from SS&C Black Diamond Trust Services. Whether optimizing for tax efficiency, managing complex assets, or securing intergenerational wealth, Black Diamond helps you bring clarity and control to the most complicated estates. Learn more at www.sscblackdiamond.com. SS&C Black Diamond, powering the future of trust and estate management. Hello, everyone, and welcome to the latest episode of wealthmanagement.com's Celebrity Estates, Wills of the Rich and Famous. For anyone new to the podcast, in each installment, myself and a guest take on a different celebrity estate and attempt to extract some key lessons that planners can apply to their more traditional clients. The idea being that celebrity estate planning stories, although often ridiculous in their details, generally have at their cores very basic issues that could just as easily apply to non-famous or fabulously wealthy clients. To learn more about estate planning and how you can better serve your clients, visit wealthmanagement.com/trusts-estates. Our monthly journal features tax law updates, wealth planning, retirement planning, and much more, written by thought leaders in the industry. That's wealthmanagement.com/trusts-estates. And we're joined today by Matthew Erskine. Matt's a fourth-generation attorney, and he concentrates on providing legal and fiduciary services for family with basic estates, as well as real estate, unique assets, or family businesses. Unlike most trust and estate attorneys, Matt's focus is ensuring financial security while preserving the ownership of unique, but often illiquid assets for the client and family. Thanks so much for joining us, Matthew.
Thank you, Dave, for inviting me.
So this is normally the part where I'd introduce our celebrity subject for the episode and tell a little bit of a story about their estate and sort of what sort of shenanigans went on. But we're going to do things a little different this episode. On the show, we often spend a ton of time stressing the need for flexibility in estate planning and trying to reinforce the idea that estate plans are living documents that should not be stuck in a drawer and forgotten until someone dies. But we don't really talk about that much what that looks like in practice. Well, Matt recently wrote an article for wealthmanagement.com, and there should be a link in the show notes, where he laid out a checklist for advisors to map out some key life events that should trigger a review of a client's estate plan, and specifically what aspects likely would need updating. We're going to go through that list and discuss the different aspects while working in some of the usual celebrity tidbits as we go. So Matthew, as we get started, do you mind briefly discussing why regular review of client estate plans is such an essential part of the planning process?
It's an essential part because things change. In other words, if you have accumulated wealth, or you have an addition to the family, or you have a fight with your kids, or any number of things, if you have somebody that, for example, if you have an elderly couple and one of them is a parent who's going to be going into a nursing home, you may want to change the way the estate plan is being done in order to shelter some of that money from Medicaid, just because the world changes every day.
Yeah, and doing these things during life is really advantageous. Trying to create an estate plan that's going to last forever is sort of a fool's errand. And once the client goes, then you're sort of you're stuck with what you have written down in a way, right? It can't really be messed with that much. But while the clients are alive and you're seeing changes happen, then it only makes sense to go in and change the plan. Why rely on the language that you crafted under different circumstances holding up, even if you did craft it to be flexible?
That is true. And it's also the fact that if you don't update the plan and it becomes outdated, you're going to lose control over the assets, or your estate is going to lose control over the assets. So if control is important, then you should be reviewing it on a regular basis.
So, turning to your article, I have the chart in front of me, and we're just going to kind of run down these sort of major life events. This is a useful way of marking, it's just a reminder for advisors when to check in with their clients about their estate plan, sort of, easy times when you hear this news to sort of bring up like, oh, hey, we should take a look at the plan because it makes sense to make sure everything works, given that this major event just happened. So we're going to start the very opposite. Normally we talk a lot about death on this show, but the first event is the birth or adoption of a child or grandchild. And so what are we looking for in that case, Matt?
Well, you're looking for, if you have the birth of a child, you may be in a situation where, just this morning I had a client and they're now on their second child and they still don't have any estate plan. And one of the things I pointed out was the fact that if something happened to one of them, they would probably need to have a guardian. Mm-hmm. And unless you have a will that appoints a guardian, the courts get to pick who the guardian is. And then on the other, if you have a grandchild, if you're making annual gifts, that's another donation, but you need to have it in something like a 529 plan or a Unified Gift to Minors Act account and be able to compound that gift. And adoption, one of the things that, when you have a formal adoption, they become as if they were your own child. So if you have them involved, but you don't want them to be treated equally with everyone else, you'll need to adjust your estate plan.
Yeah, and I think it's important to point out here, and this is a little more in the weeds than we normally get on this show, but most states, it's not if you have, when a new child is born or if you adopt a child and you already have an existing estate plan, unless you specifically exclude them, they're going to be sort of factored in as an afterborn child and sort of generally get a share of something, have some rights, unless you specifically leave them out. So this is less about like, oh, I forgot this child. I want to make sure they get something. They'll probably get something, but more, I want to make sure that everything is properly distributed now that this child is mine.
Actually, in Massachusetts, they recently changed it so that if you omit a child, it is assumed that you didn't make a mistake and that they are omitted. So it is actually quite important to include that newborn child or newly adopted child.
Yeah, absolutely. Actually, I didn't know that. That's a fairly recent change, I guess, but that's certainly puts a level of burden, which you wouldn't think people would forget to add their kids, but that you put off making the plan, or God forbid something happens, all of a sudden you've inadvertently cut someone out. If you live in Massachusetts, at least.
Well, that's why I usually do an annual get together with the client, and I basically say, what's changed in your life? Mm-hmm. People got married, people got divorced, somebody retired, whatever it is. And it always seems like the most important thing that changed, they will only mention in the last 5 minutes of the meeting.
Interesting. So the next item here is marriage, remarriage, or divorce. So what are we looking for here when we find out that a client is either getting divorced or married or remarried?
Well, what you also need to take a look at when you're doing this is, and I deal with a lot of clients that have family businesses or art collections or legacy real estate, mm-hmm. and they may have restrictions like a prenuptial agreement or a buy-sell agreement, and you have to factor that in. When somebody gets married, you have to give them, on a prenuptial agreement, you have to give them notice of everything that you own and to make it effective. So, and again, in a divorce, when you get through with a divorce, essentially the estate plan is scrapped. Mm-hmm. So you need to adjust those whenever there's a marriage or a divorce.
Yeah, I mean, the second marriage screwing up an estate plan and causing a family fight is sort of like the basis for this show. We've gotten a lot of mileage out of crazy stories based in that fact pattern.
Yeah, it's the so-called blended family, which, to paraphrase Winston Churchill, never have so many fought so hard for so little.
Yeah, my favorite, so one of my very favorite celebrity estates, and it's not funny, I shouldn't laugh because it's very sad, but it is very ridiculous, is Casey Kasem's story with a fight with his new wife was over his body. It wasn't even over his estate, really.
It was a stunningly embarrassing spectacle to watch, and I'm sure the family felt embarrassed at the end of it as well.
Yeah, absolutely. But I guess the lesson to take away from that silly one, which we've done a show on quite a while back, is that, marriage brings with it certain rights, and those rights can conflict with an estate plan that you may have been assuming would go one way, but now that there's a different marriage in place, there are certain things that are going to change unless you go into the estate plan and specifically adjust the plan to keep the status quo or not, depending on sort of what you want to happen. But in the case of Casey Kasem, the existing spouse has a lot of rights to the body, and they're tough to break up. So if you're the kids and you're expecting to get to choose where to bury dad, maybe not.
I think that in that particular family, I'm not sure you could have done anything to keep them from fighting, but at least you could have kept them from fighting over where he was buried.
Yeah, we could have taken out like the stealing and the kidnapping and the stealing of bodies maybe, and just kept it to sort of a more traditional family fight. So our next item here is the death or incapacity of a spouse, a beneficiary, or a fiduciary. These are three very different things, but they all sort of play integral roles in an estate plan.
Well, usually it's because, in part, you may appoint someone to act as a agent, either durable power of attorney, healthcare proxy, trustee, or personal representative, which is what they call executors now. And if they are unable to serve in those functions, you need to get a replacement. If you have a durable power of attorney that the person that is supposed to be your attorney turns out to be incompetent, it's not much use. And needless to say, if somebody's died, it's even worse.
And I think this is a good place to point out that a lot of times when people hear discussions of estate plans, they basically think of wills and trusts. But for most people, the items you mentioned here, your durable powers of attorney, healthcare proxies, and I think we'll touch on it a little bit later, but beneficiary designations also are sort of really the functional aspects of a lot of parts of their estate.
Yeah, it's the three things that regardless of how old or young your client is, you should have.
I know a lot of attorneys I've talked to are saying that the paradigm has shifted where you used to charge for the will and then you would throw these in. And now it's kind of the other way around, where you charge for these and then you kind of throw the will in.
I tell people, I've always charged for both, I must admit. But I tell people that having a durable power of attorney and a healthcare proxy is like buying fire insurance on your house. You hope you're never going to need it, but if you do need it, it's a real lifesaver.
Yeah, it's just a reminder that estate planning and end-of-life planning, there's a very blurred line. There's a lot going on there where they interact with each other, and they should sort of often be considered as one and the same.
Mm-hmm.
This next one is a bit of an obvious one, but if the client has a significant change in assets, now this can be anything. They could win the lottery, or it can be a liquidity event. Something, it doesn't have to be hundreds of millions of dollars, but it's something where their assets are significantly changing.
Yes, and probably the biggest transaction that almost everybody goes through is the sale of their primary residence. Mm-hmm. Most often it's somebody who is going to be moving into an over 55 housing or assisted living or something of that nature. And you'll go from not really needing any asset management for the value of the house to needing to have some asset management to maximize the return. And so it's a significant change.
I imagine this is something you see also all the time in sort of advising clients on collections and things like that, where you have this sudden change from illiquid to liquid money.
It is. Collections are a little different, although they may be like a primary residence, because collections are both an emotional and a financial mm-hmm. asset. And many times you'll have a situation where a client financially needs to sell it, but emotionally is just unable to.
So our next item here is when you change careers or jobs, or if you retire. So what are some of the aspects we're looking at there?
Many of the aspects, particularly if you're married, you get various benefits like health insurance and life insurance and disability insurance, things of that nature, along with participation in retirement accounts, 401ks or 403bs if you're in the government. And all of those need to be changed because you're no longer dealing with the HR department or the providers that you had in your prior job. The other is to be able to make sure that as, contact information in case of an emergency. I mean, does the HR have the information for who it is that you're supposed to call if something happens? And you're also, in some cases, what you have to take a look at is what your employment contract says. And one aspect is if you're going to be getting stock options or granted stock as part of your startup company, what restrictions on the ownership of that stock exists. For example, can you put the stock into a revocable grantor trust so that you don't have to go through probate?
Yeah, it's really important to point out here also that usually if someone is changing a career, that doesn't necessarily just mean they're changing their jobs. It could also just mean that their entire life goals may have shifted, which is not such an unusual thing to happen as people get older. I know as a funny example, but as for the attorney specific, my wife is a litigator who was and had a lot of litigator friends who were in public service when they were sort of young and idealistic, and those sort of jobs are great for the soul. But not so much for the wallet. And when you're 26, you don't care about that. But as I've seen them grow and have children and sort of take on responsibilities, all of a sudden it's like, well, maybe going in-house somewhere is not, that 10 years ago they would never thought about. But well, now they're gradually moving on to other careers where, because they have their priorities have shifted a little bit from they still want to help others, but they have others happen to be their children in this case often rather than people they don't know.
And you also have to take a look at what is their risk management like? Mm-hmm. Because many times, someone will say when they're, 50 years old, I'm going to go out and start my own business. I think I can run it better than anyone else. And they borrow money against their retirement account. Mm-hmm. And that's putting a substantial risk on a venture. And they really need to, have some counseling on how to moderate that risk and compensate for it.
So our next item here is if the client moves to a new state.
Yeah, in other words, every estate plan, although there's reciprocity between the states, every estate plan is dependent on the particular state that you're in. So that an estate plan in Louisiana, which has civil law rather than common law, is different than an estate plan in Maryland, which is going to be different than an estate plan in Massachusetts. So whenever you're doing that, whenever there's a change of residence, and what we see it here in Massachusetts is somebody retires and moves to Florida. And I always tell them you have to get a Florida attorney in order to do a new estate plan.
That's the New York fact pattern also, at least for us New York Jews. That's sort of the manifest destiny to eventually.
It seems to be the most popular place to go to.
But here, actually, this is a good opportunity to talk about something we haven't really brought up ever on this show and or talked about how it works, actually, is what law holds. What if I draft my will in New York and then I move to Florida and I die, sadly, in Florida? What state's law controls my will? Is it still New York law because that's where it was drafted, or is it Florida will because that's where I was and where my residence was when I died?
Assuming that there is no reference in the document saying which law applies, which sometimes you will see, the will, you are petitioning to have the will allowed in the place where you are a resident at the time of your death. Mm-hmm. So even though it may have been a perfectly valid will in New York, it will be probated in Florida, and they will do it according to Florida law. because you're in the Florida probate court. They oftentimes will reference New York law to try to interpret what the testator meant by this particular phrase. But you are in Florida and you will have to comply with Florida law.
And so this is a thing that can be especially hairy for someone who splits time. The snowbird is the obvious example here, where, they may have a bunch of assets in New York and they may physically be, in New York, but their residence is in Florida, at the time of their death. And so there is a lot of shifting around of things and a lot of confusion that can arise under these circumstances.
The other thing is, keep in mind that if you own in your own name property that's located in another state, you will have to have an ancillary administration of the will in that state. And at least in places like Massachusetts, you will be subject to that state's estate tax. And what many people don't realize that if you have, let's say, a $5 million estate in Florida, but $500,000 of that is a house on the Cape in Massachusetts that you own, in your own name, that you are going to be subject to Massachusetts estate tax. And it's not going to be on the $500,000, which is well below the $2 million limit. It is going to be based on 10% of what the calculated tax is going to be on the $5 million, which may be tens of thousands of dollars worth of tax.
Mm-hmm. So our next event here is a health event or a disability incapacity of the testator themselves.
This is how do you keep control of things when you're not going to be able to handle things. Powers of attorney, handling investment accounts, who's going to be able to pay the bills, where do the required minimum distributions go, and if you are going to need to go on to Medicaid, what sort of protections can you put in place?
Yeah, this one is interesting because a lot of times the struggle is in defining when incapacity or disability has actually happened, and that's what a lot of the fight is over. Where someone this hasn't necessarily been determined to be incapacitated, they've been making a bunch of decisions, and then later on, their family will say like, "Well, these decisions were made when they were clearly incapable of making them," and sort of the basis for a contest. This is the area where sort of having the power of attorney in place can really sort of help because it takes a lot of the question marks about that out.
In other words, the presumption is that you are competent until you're adjudicated incompetent. But that also applies to I am competent to give powers of attorney to people I trust. And therefore, until I revoke them, those people have the right to be able to be my agent. And
also they luckily have the right to continue to be your agent once you're no longer capable of making those decisions, so that the plan can continue to be updated so long as even as the person who is now suffering from disability, but not yet dead, because we still want to continually update the plan depending on their changing circumstances. And that's why they call them a durable power of attorney. So my next this is an interesting one, our next step. If a beneficiary is having struggles, right now this can be struggles with money, this can be struggles with substance abuse or mental health or any number of other things, or sort of generic beneficiary struggles. So what are we looking at here? Well, first off, if they're going to be the beneficiary of any document, make sure that it's got a spendthrift provision so that their creditors cannot attach the assets in the trust. The other is to carefully consider how distributions made to that beneficiary are going to impact them on their treatment, because addiction or mental health is an illness rather than just a moral failing, and there are certain treatments which involve having someone be accountable for their actions. You may want to give permission that a trustee can withhold a required distribution of, let's say, income if somebody is apparently going to have an issue with drugs or alcohol, and provide also that you can pay some other benefits, such as paying the rent on their apartment or paying their health insurance bill or something like that, but not give money directly to the beneficiary. And this is also where you can run into the problem of fairness quite a bit. I'm air quoting, but where it's important if you're going to make changes like this in anticipation of one beneficiary struggles, that the other beneficiaries sort of be clued in at least a little. Because obviously there's the boilerplate case of the son who's been in the business or daughter who's been in the business and is doing great and is running things, and then you have sort of the other kid who's not doing so good. And the argument is, well, do I need to give that much to the one who's already doing great? The other one needs it more. So what is fair there? Is it fair to split it up equally, or is it fair to then there's to give the one who's in the business doing better more because they've succeeded more, or is it more to help the lesser child who's struggling a little bit and take a little bit away from the one who doesn't need it as much?
I have pointed out to clients that there's nowhere in the law that says you have to be fair. And sometimes it's better to give someone the $10,000 that they need today rather than give them $100,000 20 years from now when you die. So, you have to take it all. But the critical thing is to make sure that there is adequate communication. Mm-hmm. Ultimately, it comes down to the fact that it's your money and you get to do with it what you want. And if you want to give it to one and not the other, you should communicate why you're doing that and make sure they understand. But you can't have them control what you do.
Yeah, I mean, we're seeing that sort of for a different reason with the sort of the very public, Murdoch family power struggle that's happening, and in that case is more ideologically based.
Well, that's I think because Rupert Murdoch wanted to make his irrevocable trust revocable, and it is. The whole issue of family businesses and how there has to be a point where in a family business, if you have family members who are not active in the business, or even if they are, at some point they have to be able to get their capital out. Because if they can't, and it may be under a 10-year note or whatever other terms, because if you can't, then they have no incentive not to fight you over things. Around here, it's the Demoulas family and Market Basket, which it seems like every 10 or 15 years they have another fight over the ownership.
But it's interesting to point out, though, that, a lot, at least this Murdoch fight, it's embarrassing that it's happening in the public eye, but it's happening at least while everyone's alive and around. So as bad as it is, it could have been so much worse if this was all going down sort of after he was dead, sort of, I think, as the television show Succession kind of posits that sort of fact pattern. Spoiler alert, I guess, for an old show.
I never found my clients to be either as handsome or as well put together as the people on the show.
And funny how that works with television, right?
Yeah.
So our next one is a major law or tax change. This one seems fairly straightforward. But I think the point here is not to leave it up to the client to recognize that a major law or tax change has occurred.
Yeah, and it's educating the client that things have changed. Mm-hmm. Because, let's say on the inheritance of an IRA, you may have 5 years beforehand said, oh, yes, well, if you die, your kids get to inherit your IRA. They get to take it out over their life expectancy. It'll be great. And now all of a sudden they've got to take it out over 10 years. And as I pointed out to one of my clients, the problem that you're going to have there is you are kicking that particular child into the maximum tax bracket because you've got a big IRA and you've got to take the money out over 10 years, and it'll be a significant tax burden. So you may want to do something different.
Yeah, that's actually a very funny one personally for me, because my mother just hit the age where she's starting to have to take RMDs for the first time. And so she's calling me and she's like, what's the deal with these? What's going on? I hate this. I'm just like, yep, well.
As I point out to my clients, the operative term is retirement account.
Yeah.
You're supposed to be using this according to the government for your retirement, not saving it for your kids.
Mm-hmm. So moving on, we have one of the last couple here of change in executor, trustee, or agent.
Yeah, in other words, if you get in a fight with your brother-in-law and you don't want him to be the executor of your estate anymore, you will have to make changes in all of your documents to reflect that.
what clients may not quite fully appreciate is that sometimes these titles are given to just like people you trust, where it's just like, this is my brother does this, or I'm giving it to my best friend. And whether or not that's the best way to go about it is up for debate. These are official titles that come with official fiduciary responsibilities. Yep. And that needs to be recognized. And just because you get mad with your brother and change the name of your executor in your will, there's a number of other places and documents where these things need to be updated. And it's certainly not enough to just say like, well, you're not my executor anymore, Steve is.
That is true. And the other thing that sometimes you want to change the executor from being an individual to an institution where you feel that there is personal dynamics between the fiduciary and the beneficiaries that will end up having a fight. Mm-hmm. And that has happened many times.
And so that's the last of the sort of specific call-outs. But there should also be some sort of setup for annual or semi-routine review. What time period do you favor yourself in terms of just nothing has happened necessarily, but let's just take a look at the whole thing?
What I do is on the anniversary of when my clients sign their estate plan every year, I send them a letter and say, can we get together for half an hour and go over any changes that I might have because of the laws or you might have because circumstances changed. And they usually come in and I usually charge them a nominal fee to do that, but it makes it so that we can avoid having a big problem later on by making small changes as we go along.
And I think that's kind of the moral of this whole discussion we just had, right? Is that if you make numerous small changes as you go, then you're avoiding the big problem that you can't really address with changes at all.
That is true.
So that's about all the time we have. I'd like to thank Matt Erskine for coming on and being a great guest and for coming up with this excellent checklist. I think this is a very helpful sort of guide for people who are newer to estate planning to sort of take a look at, oh yeah, this is a perfect sort of way to go about, reaching out to my clients, and just markers to easily sort of give context for starting what can be kind of difficult conversations, even once a plan is already in place.
Well, I appreciate your inviting me to come onto your podcast, and I hope that the checklist will at least be something that people can start the conversation with their clients.
And for all our listeners, I'll see you, or I guess you'll hear me, on the next episode of Celebrity Estates, Wills of the Rich and Famous. Every estate tells a story. Some define a legacy, while others highlight lessons learned the hard way. To avoid costly planning pitfalls, trust companies, banks, and wealth management firms rely on the full suite of modern solutions from SS&C Black Diamond Trust Services. Whether optimizing for tax efficiency, managing complex assets, or securing intergenerational wealth, Black Diamond helps you bring clarity and control to the most complicated estates. Learn more at www.sscblackdiamond.com. SS&C Black Diamond, powering the future of trust and estate management.
Thank you for listening to the Celebrity Estates Wills of the Rich and Famous podcast. Click the subscribe button below to become notified when new episodes become available. The information covered and posted represents the views and opinions of the guest and does not necessarily represent the views or opinions of InformaWealthManagement.com. The content has been made available for informational and educational purposes only. The content is not intended to be a substitute for professional investing advice. Always seek the advice of your financial advisor or other qualified financial service provider with any questions you may have regarding your investment planning.